you all for inviting me along to come and speak to you tonight. It's just a little bit about NACSA. So I first joined NACSA in 1995. I was a single parent. I needed child maintenance from my ex-husband. He wouldn't pay, and I was abandoned by CSA just as much as I was by my ex-husband. So after a period of time, I realised that this was going to be a bigger battle than expected. Thankfully, my days as a single parent were fairly short-lived. So I met my current husband, who was a non-resident parent, and that sort of made me have my first insight into the agenda behind the CSA, and it wasn't really that child-focused as it was sold to be. I went on back in the mid-90s to create my own regional support group in the West Midlands. That became the largest group in the West Midlands, and then moved into being on the national committee in 1999, where I became chairperson of NACSA as the organisation. So CSA in those days was very much of a hot potato. Everybody was out complaining about how it was not effective. It wasn't supporting children as it needed to be, and there was lots of lobbying at Parliament. But over the years, that died down. So NACSA became more of an actual limited company that was providing the support services to parents. Again, that's grown and that's changed over the years with more of a consultancy-based service now. But over the years, at all times, our service has been to provide the advice and guidance to parents to make sure that the law is being applied correctly for their particular child maintenance case. We provide that guidance to parents, that's both receiving parents and paying parents, to support groups like yourselves, to MPs, to lawyers, citizen advice, so a whole spectrum of people that have sort of some sort of footprint on the child maintenance service. And we are only child maintenance specialists, we're not solicitors, so we don't deal with anything apart from the statutory scheme of child maintenance. The way we work is we have an initial consultation. That is a paid for service, but we have an initial consultation. This just helps us to establish what are the issues and whether is the situation caused because of a confusion, which is quite easy through the conflicting information that CMS will often deliver. So very often that initial consultation can resolve issues as much as identify that there are issues that need to be taken forward. One of the key things that we find that's important for receiving parents is because what we often find is non-resident parents or paying parents will, they've got an issue, they've got a complaint, they're trying to speak to CMS, CMS aren't answering or just don't seem to give them the answer that they're looking for to answer their specific question. So after a while, it spirals out of control, and what they do is they just stop paying. So they said, right, CMS aren't listening, I'm just going to stop paying, and then they'll have to listen to me. So very often that initial consultation can unpick some of that confusion, and we can get the maintenance started again. So even if the consultation is with a paying parent, not necessarily a receiving parent, it can help that flow of maintenance to start again. So it is a crucial part of what we do. Following on from that consultation, we do offer services such as the full representation, audits, variations, appeal forms, mandatory considerations, just generally anything to do with the child support maintenance scheme, then we can help with. My role is primarily tribunal based, so anything to do with tribunals, appeal bundles, support and guidance on appeals. And I have, I think it was this year, maybe end of last year, also now started to do a limited amount of tribunal representation at hearings and that for clients. So that is a very, very quick recap of where we are with NACSA. Welcome to have a look at our website. However, I will say that is actually that's under construction. We're having a new website built. So come and visit us in a couple of weeks. That will look far better. But I wanted to spend tonight talking more so about something that's more relevant to the people in the group today. one of our, well, it is the biggest question that we get from receiving parents is a dispute over income. He's not declaring income properly. He's hiding it. It's not correct. Whichever way that may be, there's usually a dispute over income. So the starting point is to understand the various categories of income that CMS will use and how to bring it into effect. Starting point with CMS will always be your earned income. That is gained from HMRC. It is the figure that comes from HMRC, and CMS cannot deviate from that. That is the figure that has to be used. If you believe that HMRC figure is wrong, that is the matter you have to take up with HMRC, not CMS. But the earned income figure is the amount that's registered as chargeable to tax, registered with HMRC. It is for PAYE and for self-employed. One of the biggest confusions is people will think that a paying parent is self-employed because they work for themselves. If the paying parent is a director of a limited company, they are an office holder and they are deemed PAYE for child maintenance purposes. So it's important because the way that they calculate income is different if you're PAYE or if you're self-employed. So it's very important to see where does the earned income fit in with the whole calculation process. The starting point is earned income. If he's a director of a company, generally speaking, they will have a very low income, and then that might be supplemented by dividends. Even if CMS are aware that there are dividends payable, they will not and cannot use it unless one of the parents makes a request for a variation. So if you know that he is, and I say he, obviously that's he or she, depending on where it is, but if the paying parent is in a directorship, holds a directorship of a company, the first thing you must do, make a variation. So that brings in the unearned income that is generally the dividend side of it, which is where the bulk of the income can be found. Now, the difference there is earned and unearned income are both sums that are chargeable to tax. So they are defined in legislation as sums that are chargeable to tax. Unearned income would also include something like rental income as well. So we do get a lot of parents where they've perhaps got a portfolio of properties. So if there's rental income coming through, again, that would be brought through under the unearned section, but you can only do that when you've got a variation in place. So it's really important to make sure that you make that variation early on in the process. But your earned and unearned are both amounts that are chargeable to tax. The bigger game can be found from notional income, which again is through the variation scheme, and notional income, it's not reliant on the taxable status. So it gives you a better opportunity of being able to look at what income's there. It doesn't have to actually be recorded anywhere. And this is where you'll often find that there's additional monies that's perhaps fallen outside of the CMS view because it's not defined as a chargeable to tax income. The notional income you can get from assets, which is any asset that's over £31,250. Assets generally is going to be money, capital stock, shares, savings, bonds, property. So if there's property that is not the primary residence and it's not a property that is gaining rental income, then it could be an asset as well, net of any mortgage. Bit currency, bullion, those sort of things. But generally speaking, the most common areas is your capital, savings, shares, and property. Anything that is over £31,250 is viable for an asset, and the notional income is generated by 8% of the asset value. So if you've got £100,000, it's 8% of the £100,000 of the asset value. Notional income can be drawn from that. Probably the most common area for ladies who have exes who are hiding income and perhaps not being altogether truthful about income is what we call diversion of income. So this is one of the really, really key areas for receiving parent to focus on. So diversion of income comes with two tests. First, is there an ability to control, which is either effective or actual control. So we very often will find that he is an employee of a company that his wife owns, and she is the main shareholder or director on paper, but very clearly it is the paying parent that has the skill and the qualification and the ability to run the company. So it is effective or actual control. Doesn't have to be him named as the person with control. That is your first test. And if he's got a directorship, then generally speaking, that's going to meet that test. The second one is, has the income reduced by unreasonably diverting it to a third party or purpose? And that can be the four main categories for diversion. You have payroll. So if there's somebody being added to the payroll of the paying parent's company, and they're not perhaps contributing to the company, to the running of that company, to warrant the level of money that they're taking out, that can be diversion. Director's loan accounts, that's a very common one where diversion is found if paying parent is using a director's loan account and there's no need to do so, or is using a director's loan account to fund personal expenses. That's a common one. Retained funds, that's one of the main areas that you will find diversion of income. So an accountant will tell a paying parent to build up the funds in the company and make the company more financially secure. But when it comes to child maintenance, we're not talking HMRC law, we're talking child maintenance law. So the not the CMS so much, but the tribunal will look specifically to see whether, okay, you've got £150,000 retained funds in that company, but we don't think you need that amount. You don't need to keep that amount of money. That's excessive. So they can decide that there is money available there to take as an additional dividend or additional salary, and that could fall to be diversion of income. So again, in context, if there's £150,000 in a retained fund and the tribunal thinks, well, you only need £50,000 to keep this company afloat, so we could say there's potentially another £100,000 there that is accessible, that is available for you to take as income for child maintenance purposes, and the assessment could be made on that basis. So retained funds is a very, very key area to look for. And the other one that is most common is pension. So you will find that some paying parents will pay large sums of money into a pension fund. And there seems to be this common confusion going around at the moment. I've seen this quite a lot of late, where there is a pension guide. There's a pension guideline that says how much that you can pay into a pension according to your age. And sometimes this can be as much as 70% of your income is deemed under this FSA pension guide as deemed acceptable to pay into your pension. And CMS are getting a little bit confused with that, because what they're doing is saying, well, yes, he is 56 years old, 57 years old, so he can pay this large amount of money into a pension. That actually doesn't count. It's only if you've got no pension provision at all, can that FSA guide fit in that respect. So just be careful where diversion takes place. On average, they say around 15-20% at the most is reasonable. Anything over 20% of the income could be seen as a diversion. So those are your four main categories for diversion of income. Those are the areas that you want to be looking at, pursuing and challenging, and looking at your evidence to see whether this is where you can find additional income to boost your maintenance. So again, earned and unearned is chargeable to tax. Assets and diversion, all notional income, not subject to tax. And it's just what is available for child maintenance purposes.
Sorry, Michelle, we've got a question whether you can display your slides as the full screen, as the slideshow, if possible.
Oh, is it not as a full screen?
No, it's got the notes displaying on the left.
Ooh, how do I make it go full screen? Oh, hang on a second. I know what that will be. Hold on.
From the current slide, I
Move
think.
that out of the way. Is that better?
Yeah, brilliant. Thank you.
Sorry, I didn't realise that was still showing. Okay. So yeah, if you then have a situation where you feel that the income isn't being declared fully, what you need to do is go through the necessary steps to basically take it away from CMS, get it into HM courts and tribunals. That's where you're going to have the platform really to really get the investigation underway. You must start with a decision. So that can be a calculation, a variation, or a refusal to make a variation or calculation. But very often we find that parents are told by CMS, oh, he's not paying, or the pay schedule's too low, or we'll put it to appeal. You can't appeal that. You can only appeal a variation or a calculation, or a refusal to make a calculation or a variation. So anything that falls out of those particular areas, debt, arrears, repayments, pay schedules, can't appeal any of those. You can only appeal on an actual calculation. So put in some sort of request to say that you want a calculation taking place if you haven't got one already, and wait for a decision to be made. Once you have your decision or a refusal to recalculate, you have 30 days in which to raise a mandatory reconsideration. So you must do that. They do say the online portal now, you can do that by each of the sections on the portal. So if you're going to contest his income, you can click on there, report change of income, and you would put on there something about why you don't believe that the income is what it is. I don't fully trust their systems at the moment, so I would always back that up by sending a letter through the upload a document option, and ask for a mandatory reconsideration so that you've got that within your 30 days. At some point, they will make a decision on that mandatory reconsideration, and they will issue what we call the mandatory reconsideration notice. You cannot go to appeal until you've got that mandatory reconsideration notice. And what I will say is when you get that, be sure to check the dates. So each notice will have the sentence also at the top, and then it will tell you exactly what decision has been considered under that MR notice. So it will have refusal to supersede, decision made on whatever date, and the effective date. So it's really important to check your effective date, because I have had so many cases where somebody's taken a decision to appeal and they've actually appealed the wrong decision. It's not the decision that they want to appeal. If you've gone through the process, you will have probably lost all of your time to appeal the correct decision. So make sure that you look at the correct effective date on that MR notice before you take the next step, which is taking it to appeal. So you get your MR notice. From there, you have 1 month in which to lodge your CS2 form, which then goes directly to HM courts and tribunals. It's the lodgement centre, the direct lodgement centre, which is now based at Harlow. So anybody who's done appeals, how long has it been now? Probably 18 months, I suppose, 12, 18 months. You would have perhaps sent it to Bradford before. The centre has now changed and it's Harlow, apart from if you're in Scotland, to an extent it's Glasgow, but for England and Wales, your form must go to Harlow. That gets sent off. CMS should respond within 42 days. It's actually taking about 5 to 6 months for those bundles to be issued. So you're going to be in it for a little bit of a waiting game. But it takes around 6 months for that appeal bundle to be issued. Once you get it, then you can start to have a look at what sort of information the CMS have used to make their decision. Is there anything in there that you want to add, or that you feel that the tribunal needs to direct the other party to provide? So you can ask for the directions to be given to you. And the cycle will keep going. Directions, hearings, more evidence, more responses. A hearing itself can take anywhere, if you're disputing income, a hearing can take anywhere between 1 and 3 to 4 years. So again, it's not a quick process. Now, it will be backdated to whatever the effective date was on that MR notice. It will be backdated, so you would get a lump sum of arrears that are due, but it does take time. So you have to just be aware of the timescales involved. And bear in mind that if something is in appeal, CMS won't carry out any enforcement. So your enforcement action will generally stop. If he's not paying, CMS aren't going to do a lot about it. So it is a lot of factors that you need to consider into whether or not you want to go ahead with appeal. Change it on there. When you get your appeal bundle, you should get sort of a small selection of pages, and it'll all be paginated through, but this will be the cover sheet of an appeal bundle. So this, if you see this, you know you've got your appeal bundle. Now, it's very important that you take note of these 2 dates. You've got your effective date and your date the decision was notified, because this is the date that the decision will be backdated to. So if it's not done for 3 or 4 years, it would get backdated to this date of January 2021. The tribunal will need to consider what were the facts, what were the circumstances as at that effective date. So what happened 5 years prior, no interest, no relevance. So don't clog your bundle up with issues from years ago. They are looking specifically at what was the situation as at that effective date, which brings me back to the point about making sure that you've appealed the right decision. The date of decision that was notified, this date here is important, because the tribunal only have jurisdiction to consider any situation between those 2 dates. So if, for example, you've taken in that he's not declaring his income, he's got this fabulous lifestyle and he's declaring 8,000 a year salary, you know, something's clearly not right, the tribunal will look at January 21 as being their key date. If we can see that the paying parent won the lottery on the 30th of January 2022, tribunal can't take that into account because it came after that date of decision, that notified date. If he'd have won the lottery on the 20th of January 22, it falls within the scope of that tribunal jurisdiction, so they can take it into account. So these 2 dates are really, really important when you get to a tribunal, because that's all the tribunal are going to look at, what's happening in those 2 periods. And when I say that they're going to look at those 2 periods, tribunal will ask for financial disclosure for slightly before that effective date. And the reason being is that they need to sort of build up a pattern of an idea of what sort of spending pattern the paying parent has before that effective date. So they will ask for disclosure before then, but it's only to build a picture. They can't make a decision that was years before or after that notified date. So it is important to keep those dates there. So this is just a quick example. When we say about looking at the MR notices and the effective date, to put that into context, if you had, let's say you made your application January 22, you put your variation in, you're still not happy with it, you make your application to tribunal, so you've got your appeal lodged in the June 22. That process is going to take potentially up to December, 2025. Could be 3 years, quite easily take 3 years. Well, in that time, you've got an annual review from 23, from 24 and 25. So all of these decisions are separate to the decision you've put under appeal. Ideally, what you want to do is appeal each one of these. Each decision that comes out, appeal it, go through the MR process and put it to appeal. So you may well have 6, 7, 8, 9 plus appeals altogether. It's unlikely to be that much, but you will probably have several appeals altogether and they'll all be heard at the same time. But the benefit of doing that is that The tribunal then has the opportunity to look at each effective date. So what happens here in January 22 will be relevant to that decision. But they also then can see how things have changed by 23, 24 and 25. So each year gives them a new effective date to look at the circumstances, which might be really quite relevant if, for example, you've got an assets decision or the diversion is based on something like retained earnings, because that will build up over the years. So having those three decisions under appeal as well just gives the tribunal that longer period that it can consider the decision, and also that gives greater authority over decisions going forward. So CMS are unlikely to then undo everything, and then you've got to go start the whole process again. It's a more secure decision if it's made by tribunal than it is from CMS. So if you've got those all under appeal, they've already been decided at the same time. It doesn't mean that you've got to go back again year after year. So it is important to think about appealing other decisions if the same problem is still happening there as your first dispute. So once you've got your decision into appeal, the tribunal has to take what we call an inquisitorial approach. So they have to look at and they have to ask all the right questions. They have to request all of the relevant financial disclosure to be truly satisfied, has the CMS made the correct decision or not? So it is a duty, a legal duty of the tribunal to take that inquisitorial approach. They will direct the provision of financial disclosure, and we do get asked an awful lot about, well, he won't provide it, or he's just going to blank everything out. And we have had, very commonly have, appeals where there's 300 or 400 pages and it's just completely black pages because it's just redacted everything. Well, that's of absolutely no use or no value and should be deemed as non-compliant. Non-compliance, there's no sanctions, so he doesn't necessarily have to provide it. He's not going to come under any prosecution for not complying, but the tribunal will draw what we call adverse inferences. So if you've been asked to provide something and the paying parent decides not to do so, the tribunal can draw from that the assumption that had you provided it, it would be detrimental to your case. So we'll take from that there is some foundation in the allegations that's been made in the appeal application. Now, if you think that your ex is not likely to provide or comply with those that financial disclosure request, I always encourage my receiving parent to have an idea yourself what you believe is the actual income. Don't make it wildly unrealistic. Have something that's credible, that you believe, and why you believe that it is his true income. Because if he doesn't comply and there's no information there to suggest what his income actually is, then they are more likely to be persuaded by the evidence that you've put forward, including, you might say, well, when we were married or when we were living together, he always had over £100,000 and he's still doing the same job just because he works for himself now, not at X, Y, and Z employer. And that's credible allegation. So they would use that as a persuasive argument. So always have an idea yourself of what you believe is the true income and why. And again, as I've referred to there, if you've been in a relationship for a long period of time, you'll generally know how he works his finances and how he operates. I know that's not the case for everybody, but if you do know how that operates, don't be frightened to put that to the tribunal, because they will listen to that and take that on board. When you've got your bundle, it's really important to keep it in order. Make sure that any time that further evidence comes forward, it should paginate on, it should run consecutively from what's already in the bundle already, and report any missing pages. All parties should have exactly the same bundle, which is why it's the tribunal's responsibility to prepare and issue the bundle and paginate it, or even if you're sending evidence in, the tribunal will process it and send it back to you to add into your bundle. So make sure it all runs on, make sure that you've got all the pages. If there's any pages missing, report it straight away, because you don't know what evidence that is and how crucial it may be to the final findings. Again, keep focused with your effective dates and your notified dates, because that is all the tribunal can look at, is in between those two times. And again, we don't have lifestyle inconsistent now that we used to have on the old legacy schemes, but all you have to do is raise a credible allegation. There's a judgment, CP versus Secretary of State, I think it is, that that basically says, as long as there's a credible allegation that this income isn't fully declared, it then becomes the tribunal's duty to investigate properly to find out what is the correct income. So if he's only declaring £8,000 a year salary and is living in a 7-bedroom mansion in the middle of Hampshire and is driving 2 or 3 Porsches, then clearly something's not right. That's not to say that it's not being funded by other means, but it's credible allegation that at least means that the tribunal's got to make that investigation. You can ask the tribunal to direct the paying parent to provide certain information, but it's not a fishing exercise. It's not that you can just ask him to declare it because you want to see his personal information. You've got to make it credible. You've got to put your reasons as to why you believe that income is being hidden. But as long as there is that credible doubt, you can ask the tribunal to direct the paying parent to provide certain information. And it is always really, really important to look through all of your evidence. And again, we can have another session maybe later to talk about how you might analyse your evidence. But make your questions, make your bullet points, keep notes about what's said in the oral evidence, because although when you get to a tribunal hearing, the onus will very much be on the paying parent. A lot of the questions will be put to him. You may actually say very little, but you will be given the opportunity to raise anything that you feel hasn't been covered or that you disagree with that may have been said in oral evidence. So make sure that you have a list of questions, a list of points of the things that you definitely want to be answered within those proceedings. And tick them off. And if there's anything there that hasn't been answered, when the tribunal hands over to you to raise anything, that's your time to do so. That's your opportunity, because the first tier tribunal is your fact-finding session. And after that, if the decision is made based on the facts that they have collected through that process, so it's too late to raise it afterwards, that's your time to raise anything that you feel needs to be addressed. And also, again, thinking about your later calculations while you've got one decision under appeal, think about all the other decisions that might be made by CMS. Do they need to be appealed and all linked together so that they're all heard and all of the different effective dates are covered at the same hearing? And then once all of the proceedings have finished and you've grown a few years older and the kids have grown up that little bit more, the decision notice is sent to all parties, but it is a CMS responsibility for implementing that decision and carrying out the adjustments of the account, which can take several weeks, even months, and they're not that good at doing it. So you do need to make sure that you look carefully about what has been implemented from the first tier tribunal decision and what impact has that had on your actual arrears. So it is really important to get that checked at the end of it. Decisions are often sent out in the post. So if you're looking online, you probably won't find it. Occasionally they're on there, but they're generally sent out on post. What we always suggest you do is monitor your actual arrears balance, because if you see that changing, that would suggest that they're doing something, and then I would expect those decisions to come in the post. If you haven't had them by a week or two after those signs on your portal, then I would certainly be chasing the CMS and asking for copies of those first tier tribunal decisions. When we went back to the beginning slide about the notional income, so earned and unearned, because they're taxable amounts reported to HMRC, those figures can be changed year on year. Any notional income that's generated from assets or diversion will actually roll forward each year. So if we say you've appealed in 2019 and they've decided that there's £30,000 diverted income, That diverted amount will then run into 2020, 21, 22, and 23, if that's applicable by then. It will run into each of those subsequent years. Those are what we call impacted decisions. And impacted decisions are ones that are still made by CMS, but they've been impacted by the findings of the tribunal. An impacted decision has to still go through the MR process and then appeal if somebody wants to contest it. So you may find that if a diversion income has been said from years prior and it's been used in all of the other decisions, a paying parent might then try and appeal an impacted decision, but it is a CMS decision, so it does have to go through the MR process for that. If you are in an appeal, but it actually isn't your appeal, it's the other party's appeal, you can't piggyback off that to raise the point about diversion of income or assets or anything like that. But if his appeal concludes with an outcome that changes that decision, you could then put your variation in against the revised decision. So if he's changing it because, let's say, shared care changes, when that revised decision happens because he won at his tribunal, but you know that there's an issue there about his income, you have 30 days in which to put your variation in against that revised decision, which will then kickstart the process for you to then question the appeals. So even if it's not your appeal, it's not necessarily lost. You can't hijack his appeal, but you can sometimes use the advantage of the fact that that decision will be revised. Then you can make your variation if need be to get that changed. And that, I don't know where the time scale has gone, so I don't know if I'm in my time frame there, but that is a very, very, very tip of the iceberg with CMS. But if anybody's got any questions, I'm more than happy to help.